Charles Goodyear versus Horace Day, 1852, was a courtroom fight over who actually owned the rights to vulcanized rubber, the chemical process that turned a sticky, temperature-sensitive gum into a durable industrial material. The case became known at the time as the Great India Rubber Case, and it was argued by two of the most prominent trial lawyers in the country, including a sitting United States Secretary of State who was paid more for 2 days of argument than the inventor he represented had earned from his own patent across several years. Rubber had been a commercial dead end for years before this case. In its raw form, it was called India rubber, or gum elastic. It turned brittle and cracked in cold weather and went soft and gummy in heat. American manufacturers who tried to sell rubber shoes, coats, and other goods in the 1830s found that customers returned products that had melted or rotted within months. Several early rubber companies went bankrupt because of this defect, including the Roxbury India Rubber Company in Massachusetts, the very firm whose failing products first caught Goodyear's attention. Charles Goodyear, a hardware merchant from Connecticut, began experimenting with rubber in 1834 after visiting the Roxbury India Rubber Company in New York and examining one of its failed products. Over the next 5 years, he worked through a series of treatments, including mixing rubber with magnesia, nitric acid, and other compounds, trying to stabilize the material. He had no laboratory and no steady income. He pawned his furniture, sold his children's school books, and was jailed for debt multiple times in Massachusetts, Connecticut, and later in Europe. By his own account, his family went hungry during these years, and at one point he learned his 2-year-old son was dying only after walking 10 miles home from an unsuccessful errand to find financial backers. In 1837, Goodyear came into contact with Nathaniel Hayward, an inventor in Massachusetts who had found that spreading rubber with sulfur reduced its stickiness. Hayward patented this method in 1839 and assigned his rights to Goodyear for $3,000. Hayward's process was a partial fix. It did not solve the problem of rubber melting in heat. Goodyear kept experimenting with the sulfur treatment, and in 1839, while working in Woburn, Massachusetts, a piece of the rubber and sulfur mixture came into contact with a hot stove. Instead of melting, it charred slightly and held its shape. Goodyear recognized that controlled heating, rather than melting, was the missing step. He spent 5 more years refining the timing and temperature needed to reproduce the result reliably, a process he eventually named vulcanization, after Vulcan, the Roman god of fire. Hayward later came to regret selling his rights so cheaply. Once vulcanization began generating real income, Hayward went before the Commissioner of Patents to argue that he had only ever assigned a 14-year term to Goodyear, not the additional 7-year extension Goodyear was separately seeking, and that he had never been paid in full for the original sale. Hayward's appeal was rejected, and the record from that proceeding shows Hayward himself admitting that his sulfur treatment alone had little commercial value without the heating step Goodyear later discovered. The episode meant Goodyear was fighting off claims from his own former supplier at the same time he was fighting outside copyists such as Day. Goodyear filed for a United States patent on the process, but the application took years to complete because he could not afford the legal fees. While he delayed, a sample of his rubber reached Thomas Hancock, a manufacturer in England, through an agent who had shown it to potential British partners. Hancock reverse-engineered the formula by scraping and smelling samples, and filed his own British patent on November 21, 1843, several months before Goodyear's American patent was issued. Goodyear received United States Patent Number 3633 on June 15, 1844. Hancock later admitted under questioning that he had first seen a sample of vulcanized rubber in the hands of Goodyear's own agent, and at one point offered to share his British royalties with Goodyear. Goodyear refused the offer, sued for sole ownership in British and French courts instead, and lost both cases, leaving him with no enforceable rights to vulcanization outside of the United States for the rest of his life. Because the chemistry behind vulcanization was simple once known, just rubber, sulfur, and controlled heat, the process was easy to copy and hard to police. Goodyear had also licensed his patent cheaply to multiple manufacturers out of financial desperation, in some cases for as little as half a cent per pair of shoes produced. Other manufacturers ignored the patent entirely. Goodyear and his licensees responded by filing infringement suits. Over the late 1840s and early 1850s, Goodyear's side brought more than 200 lawsuits against rubber producers across the country, and Goodyear personally pursued 32 infringement cases all the way through to final appellate rulings. Horace Day was one of the manufacturers Goodyear's camp targeted, and the conflict between the two men predated the 1852 trial by several years. Day operated several rubber goods companies in New Jersey and New York, and had already crossed paths with Goodyear's patents directly. In a separate patent interference proceeding over a machine for manufacturing corrugated or shirred rubber goods, Day won against Goodyear at the Patent Office, receiving his own patent for the device in October 1844, backdated to June of that year. One witness in the later litigation, a worker named Horace Cutler, testified that he had personally written out Goodyear's formula and given it to Day, and had shown Day how to test the compound by heating it on a stick over coals, in exchange for $50. Day argued in multiple forums that Goodyear's vulcanization patent was invalid because it was not truly original. His position was that contributions from Nathaniel Hayward and other experimenters meant Goodyear could not claim sole ownership of the process, and that granting Goodyear a monopoly improperly blocked manufacturers like himself who had been working with similar materials independently. Day was not a minor figure in the industry. He ran one of the larger rubber goods operations in the country and had the resources to fund a sustained legal defense rather than simply pay a license fee, which is part of why Goodyear's licensees decided his case needed to be fought all the way through trial rather than settled. By 1851, Goodyear's licensees, a group of New Jersey and New England shoe manufacturers referred to as the Shoe Associates, decided the dispute with Day needed to be settled decisively in federal court. They retained Daniel Webster, then serving as United States Secretary of State under President Fillmore, to argue the case directly. Webster was paired with attorney James T. Brady for the plaintiff's side. Horace Day's defense was handled by Rufus Choate, a former United States Senator and one of Webster's longtime courtroom rivals, along with attorney Francis B. Cutting. The pairing of Webster against Choate drew attention on its own, since the two men were widely regarded as the two finest courtroom orators in the country and had faced each other in earlier high-profile cases. The case was argued at the March term of the United States Circuit Court for the Third Circuit, sitting in Trenton, New Jersey, before Justice Robert Greer of the Supreme Court and District Judge John Dickerson. By Webster's own account, he put less than an hour of direct preparation into his argument, relying instead on decades of courtroom experience and a thorough briefing from Goodyear's patent counsel. Day's defense built its case on what Webster's side described as fragments, small citations of sulfur here, lead there, partial heating experiments by other people, without ever identifying a single rival inventor who had completed the full vulcanization process before Goodyear. Webster's argument turned directly on this gap, pressing the defense to name the actual person, if one existed, who had discovered vulcanized rubber before his client had. No such name was produced. Justice Greer delivered the court's decision on September 28, 1852. The ruling found that Day had failed to demonstrate that he or anyone else had discovered and perfected the process of manufacturing vulcanized India rubber before Goodyear had. The decision affirmed Goodyear as the sole inventor of vulcanization under American patent law and was treated at the time as the definitive resolution of years of overlapping rubber patent disputes. The financial terms of the case were as notable as the verdict. The Shoe Associates paid Webster a fee reported at $15,000 for his role in the trial, a sum that exceeded what Goodyear himself had personally earned from licensing his own invention up to that point. Webster's involvement in the case turned out to be one of the final courtroom appearances of his career. He died at his home in Massachusetts on October 24, 1852, less than 1 month after the decision was handed down. Winning the case did not resolve Goodyear's financial troubles. He continued to license the patent at low rates and continued to spend heavily defending it and promoting new uses for vulcanized rubber. In 1851, he had borrowed money to build an elaborate display called the Vulcanite Court at the Great Exhibition in London, furnishing it with rubber furniture, musical instruments, and inflatable balloons, 6 feet across. He repeated the effort at the Paris Exposition of 1855, where his unpaid debts from the exhibit led to his arrest and imprisonment in France. While in a French jail, Emperor Napoleon III awarded him the Cross of the Legion of Honor, which Goodyear's son delivered to his cell. In 1858, citing the financial hardship he had endured while developing the process, Goodyear successfully petitioned the United States Commissioner of Patents for a 7-year extension of his original patent. Horace Day did not let the matter rest there. Years later, in 1864, Day published a formal argument before the United States Congress, opposing any further extension of the Goodyear patent, restating many of the same originality objections that had been rejected in Trenton more than a decade earlier. Charles Goodyear died in New York on July 1, 1860, purportedly while traveling to see his dying daughter. By that year, industries built on his patents employed about 60,000 people and produced roughly $8 million worth of rubber goods annually. Goodyear himself had earned close to $163,000 in licensing income over his lifetime from a patent that helped build an entire industry, yet he died owing creditors close to $200,000. He held 60 patents in total related to rubber manufacturing. The Goodyear Tire and Rubber Company, founded decades after his death and with no direct involvement from his family, later adopted his name in recognition of his role in making rubber a viable industrial material. The Goodyear name kept generating courtroom conflict even after Charles Goodyear's death. His brother Nelson Goodyear had separately patented a hard rubber compound used for dentures, and a company called the Goodyear Dental Vulcanite Company later acquired those rights and ran an aggressive licensing campaign against dentists nationwide, demanding annual fees that started at $35 and rose to $50 if dentists were slow to pay. More than 2,000 cases were filed against individual dentists during this campaign, and contemporary newspaper accounts describe the company's agents bribing dental office staff and questioning neighbors to gather evidence of unlicensed rubber denture work. The campaign had no direct legal connection to the Day case, but it shows how far the patent fights that began with Charles Goodyear's chemistry extended into other corners of American business. The Great India Rubber case remains one of the most cited patent trials of the 1800s, both for its unusual lineup of courtroom talent and for how clearly it illustrated the gap between inventing something and profiting from it. Goodyear secured the legal title to vulcanization in Trenton in 1852. He spent the rest of his life in debt anyway. If you enjoyed this video, subscribe so you'll never miss another episode.